Lesson 47. What happens in a civil case? Let's take a look at the procedure of when one individual takes out a lawsuit against another individual. This is civil law. Bringing suit. You start by hiring a lawyer who files what's called a complaint. A complaint is a formal statement naming the plaintiff, that is the person who is bringing the nature of the lawsuit, as well as the defendant. The defendant is accused of some wrongdoing. Again, no crime has been committed in civil law, but some damage has been done, some injury incurred. And so the complaint names the plaintiff and the defendant, as well as the nature of the lawsuit. I'm bankrupt, but I'm suing several wealthy individuals. The court then sends the defendant what's called a summons. A summons. This is a document informing him or her of the lawsuit against him or her and ordering him or her to appear in court on a given date and time. So the defendant is summoned. The response of the defendant is called the answer. Of course, the defendant will hire an attorney, respond to the charges with an answer to the complaint. Here's an example of a summons in a civil case. You are hereby summoned and required to serve upon plaintiff. The complaint and the answer together equal the pleadings of the case. The pleadings of the case. Before the trial starts, each lawyer takes the time to check the facts and gather evidence from the other side. This is called discovery. Now, this is a really important part of the process. Going to court is not like playing poker. You don't try to hold your cards. You show your hand. You meet with the other side, and this is true on both criminal law and civil law. I really want to stress this. You show your hand. You say, look, these are the witnesses I have. This is the evidence. This is who we're going to call to testify. Because you're actually trying to settle the case out of court. In civil law, you don't want to go to court. You want to settle. So discovery is a really important part of this process. I'm going to skip some of these cartoons. So you're going to have a conference, pre-trial conference. You're going to clarify the differences between both sides, and you're going to lay out each other's hand. And say, look, okay, let's see if we can resolve this or settle this without going to court. You may decide upon learning of the other side's case that your case is weak, and so you decide to drop the suit. Or the defendant realizes the case against him is very strong and offers a settlement. So let's say your lawsuit is you're suing for $20,000, and you may have a settlement of $10,000 or something like that. You have a settlement. Either party may propose a settlement at any time, and this is true during the trial as well. At any point during the trial, you can propose a settlement. You're suing someone for $100,000. You're going to trial. You realize the case is not going that well on your behalf, so you offer a settlement. Either party can do that at any time. Mediation is another way to try to resolve disputes. In mediation, each side is going to listen to the other, while a trained mediator is a third party, a neutral party, tries to keep the lines of communication open. A step beyond mediation is arbitration. This is when you have a professional arbitrator who reviews the case and resolves the dispute. Usually in in arbitration you have a federal judge. Now, for arbitration to work, both sides must agree to it, and the ruling of the professional arbitrator is binding. It's binding. They must accept the ruling by the arbitrator. It's another way of resolving a civil dispute without going to court. And just like most cases are plea bargained in criminal law, most cases are settled in civil law. They're settled before the trial. Outcomes of trials are hard to predict. Courts have a large backlog of waiting cases. It may be years before a new case comes to trial. They're time-consuming and expensive. But if the case actually goes to trial, it's a little different than in a criminal case. The plaintiff does present its side, followed by the defendant. The threshold in a civil case is a preponderance of evidence rather than beyond a reasonable doubt. In a criminal case, remember, beyond a reasonable doubt is all but certain. A preponderance of evidence is 51% of the evidence is in favor of the plaintiff. In a civil case, the defendant must take the stand. That is not the case in criminal law. You have a Fifth Amendment right against self-incrimination. But in civil law, the defendant must take the case or he forfeits the case. Your jury size may differ as well. You can have a jury as small as 6 people, as large as 12. In all criminal cases, a jury is 12 jurors. That's not the case in civil trials, though. It could be smaller. Now, if the plaintiff wins, the remedy is set. In other words, he gets the amount that he was suing for. Okay, it's a compensation for your pain with a cash payment. You're suing for $100,000 and you win your case, you get $100,000. So if the plaintiff wins, the remedy is set. If the defendant wins, the plaintiff gets nothing and must pay the court costs. So that is to try to reduce the number of frivolous lawsuits, trying to, taking someone to court without really a strong case on your side. We call that a frivolous case. If you lose in court and you're the plaintiff, you have to pay the court costs in addition to getting nothing. Appeal, this is different as well. Either side can appeal the verdict to a higher court in civil law. That's not the case in criminal law. Remember, if the prosecution loses, the defendant is acquitted, he's set free, and can never again be tried for that crime again. That's the Fifth Amendment against double jeopardy. But in civil law, either side may appeal. So here's the civil case procedures. You have the plaintiff hires an attorney who files a complaint. The court then sends a summons to the defendant. The defendant writes a written answer. Those are the pleadings in the case. The attorneys get together to exchange pleadings documents or discovery. Sometimes during this phase or stage in the procedure, maybe you have mediation or arbitration if both sides agree. Number 5, attorneys for plaintiff and defendants argue the case in court if it does go to court. But remember, most civil cases result in settlement outside of court. Then you go to court, you hear the case. The defendant has to take the stand in civil law as opposed to criminal law. You have a preponderance of evidence as the threshold of guilt, not beyond a reasonable doubt. and either side may appeal. So that's the procedure for a civil case, and that concludes Lesson 47.